Good evening. This is Laws 11057, Week 2. This is Introduction to Law, and it's the 22nd of July 2015. Last week we covered most of the commentary that I wanted to cover for Week 1, but I didn't quite finish. And the part that I didn't finish related to the material which you'll find in your textbook, The New Lawyer, which I think is an excellent text. And I do like the way in which it's laid out. You'll see that the first part deals with chapter 1 to 5, which is about knowing the law. The second part deals with the issue of doing the law, that is practicing in the law. And the third part relates to being a lawyer. Now I'm just going to ask Shivana and perhaps Lisa, if you could mute your microphones, that would be excellent. Bottom left-hand side. Thank you very much, Shivana. Lisa, can I trouble you to do that as well? You should be able to find it on the bottom left-hand icon of your machine. Thank you. And welcome everyone for attending tonight. We really appreciate it. So there is the issue of knowing, doing and being a lawyer, which is relevant to these studies that we're looking at. There are a number of threshold outcomes that I would ask that you please look at. And that's knowledge, ethics and professional responsibility, thinking skills, research skills, communication and collaboration, and self-management. So they're the threshold learning outcomes that we hope to achieve through studying this course. Does anyone find that those 6 are just a little odd? Is there something odd about that? You're studying law, and these are the outcomes we're trying to achieve. Knowledge, ethics and responsibility, thinking skills, research skills, communication and collaboration, and self-management. To give you a hint as to what I'm getting at, when I studied Introduction to Law back in the 1970s, there was only one of those designated as a threshold learning outcome. There wasn't 6, it was only 1. Which of those do you think it was? It's all about us and the way we learn, says Emma. Yes, I think that's right. So what do you think the one of those 6 thresholds was me? Ethics? No, certainly wasn't. That became very important very quickly as I practiced in law. Self-management? No, it wasn't that one either. Nick's, Diane's got it, Nick's got it. Yep, knowledge. When I went through uni, there was one threshold learning outcome, and that was simple, knowledge. There was really very little, nothing essentially about ethics and professional responsibilities. Thinking skills were, I guess, were part of it. Research skills were pretty limited. It was pretty much you go out and learn on the job. There was really nothing about communication or collaboration, and definitely nothing about self-management. So the point I'm trying to make is that the way in which law is taught now is much more reflective of the way it should be. We deal with many more issues. And why am I doing this? Whoever hasn't, Tim, I'll just get you to mute your microphone if you would, Tim. Just down the bottom left-hand side. You should see the little microphone icon. Just click on that. That's it. You got it, Tim. Thank you very much. I appreciate that. So the reason I'm stressing this now is that when it comes to the examination, it won't be an examination purely about knowledge like it was in the old days. The examination is very likely, here's an exam tip for you, it's very likely to involve some questions, or a question at least, about self-management. And I'm going to talk about this a lot during the course. And remember last week, I talked about the issue of lawyers having stress as a real issue. And law students are in that category as well. Top the ratings, we did, in terms of stress levels and issues concerning that. So self-management is a really important part. We talked about that last week as well. Okay, let's talk about law as a profession. I think you've all provided some really great responses to the questions which have been posed in relation to this in your worksheets. So when we talk about a profession, what we're really talking about, originally at least, is something that was self-regulated. That was essentially the definition of a profession. It's not like that now. we are heavily regulated in our profession. It's not a self-regulation as it was when I started. There's a whole range of different environments that we work in, and lawyers can either be, in general terms, a generalist or a specialist. And I'd like you to think about whether you want to practice in a more general way or you wish to specialise. Why is that relevant? Well, you need to focus your study. You need to think about what you're going to do. It follows on from my general topic of think about the end result and work backwards. So I'm asking you to do that in a much broader sense now. I'm asking you to think about what you would like to achieve as a result of studying this course, or given that I'm tailoring this to those who wish to practice, the whole course is tailored to that effect. How do you want to practice? Where do you want to practice? Do you wish to specialise? There are a lot of advantages in specialisation. And can I just say, one of the things that may be relevant to people that are studying this course is that on average, I think it's fair to say, the people studying this course online would be a little older than those undergraduates that are doing first-year law at, say, QUT or UQ. Certainly when I started studying law, I think I was 17. So a lot of people were like that. So a lot of people in this course are a bit older, a bit more experienced, and may have some experience under their belt in different disciplines. Now, I'll just give you this to think about. If, for example, I wanted to brief counsel in relation to a complex issue involving the Australian Taxation Office, if I was aware that a particular barrister had worked at the Australian Taxation Office and was a specialist in dealing with taxation issues, do you think that I might be tempted to brief that barrister, even if their fees are a little higher than someone who is very good but works in a more general way? From the other perspective, those people that do specialise in areas such as that may find that life is less stressful for them than having to cater for all sorts of areas, and also they can earn a better living. Also, there is an advantage of being able to refer to colleagues and receive referrals from colleagues. So you're not necessarily competing with the person who's in the office or the room or in the firm next door to you. So I think that that's important to think about from this point of view, in that I'm asking you to consider now strategies to help you in practicing law at the end of the day. And this is something seriously that I want you to consider in terms of what you're going to do. Okay, probably more than tempted, says Rowan, in terms of that decision that I put forward to you. Now, having said all that, I've got a pretty gritty practice that does cover a number of fields. My day job is almost exclusively dealing with criminal law litigation these days, and has been for some time. But I do hear matters on the Queensland Civil and Administrative Tribunal, and in that regard I might hear matters that relate to guardianship or building disputes or tree disputes, administrative law, that is review of decisions, etc. So the whole range of different things that I practice when I'm hearing cases as opposed to arguing cases. And then, of course, I've got this outlet through the university as well. So, and don't take this the wrong way, but I tend to think of the work that I do with the university as my hobby. So, for example, in particular, I take environmental law, and I don't practice in environmental law, but I'm really interested in it. So for me, it's a really great outlet. I don't have a shed. I'm not a person that tinkers on motors. I don't do woodwork. So for me, it's a bit odd, but a hobby is sort of studying environmental law and then being able to teach it as is a bonus and getting paid for that as well. So think about what you want to do, where all this fits in with you. And as I keep saying, don't take it too seriously. Don't take the study of law too seriously. Don't take the practice of law too seriously. Now, I'm not suggesting you don't do a good job, but look, there's a fellow called Aaron Baddeley. For those of you that may be golfers or interested in golf, you may have heard his name. And I read something where Aaron Baddeley, who's one of the world's best putters of the ball, said, don't try too hard, don't think about it too much. And he just allows the motion to happen. it's kind of the same thing when you're practicing in law as well. You know, understand what you need to do and do the job, but do it calmly, do it sensibly, and to a degree follow a formula, but don't take it too seriously. You might say, why are you saying all this? Well, again, it keeps coming back to that issue of resilience and planning on how you're going to go about doing your work, how you're going to go about doing your study. So enjoying it and being prepared for it and embracing it is a big part of that. Okay, are there any questions from that? I'm doing a lot of talking, I'm sorry. Thanks for your patience. All right. Chapter 1 of The New Lawyer deals with the reality of legal practice. We didn't get any of this when I was at law school. So lawyers help people, they give clear advice about complicated problems, they're negotiators, they're advocates, and they read a lot. I don't think any of that would surprise you. What are the attributes? Clarity of thought, good communication skills. Now this is important, even better listening skills. Well organised, really important. Technologically capable, extremely important. Committed, yes. Personable, yeah, that helps. Flexible and understanding and tolerant of people, that's really important. And having good analytical and problem-solving skills. I mean, I don't want you to come into this study thinking that what I'm expecting you to do is simply repeat a list of things that are in the textbook. As I said to you, as we did things back in the 70s with mnemonics and a list of words that would give me a clue to remember that list in an exam, in a closed book exam, we don't do that anymore. I really want you to look at those list of attributes on page 10 and say, where do I fit in with this? Where are my strengths? Where are my weaknesses? Thinking backwards, okay, if they're the things that I need, and in order to undertake the practice of law relatively stress-free, if I need those skills, what am I going to do now, working backwards, to ensure that I can get there by the end of the day? And many of those skills, of course, translate to the study of law. So think about that and actually give me some practical examples or statements as to how you are going to attain those skills, or if you do have the skills already, how you're going to enhance those skills. Okay, page 13 deals with work sectors: solicitor, barrister, private, government, academic, corporate or community. Or you might be like me and think, I want to have a bit of all of those things, which I actually do. But most people like to specialise, and I think that's probably, generally speaking, the better way to go. Okay, so what I've been doing so far is categorising law in a number of different ways. Another way of doing it is the Priestley 11, which deals with the practice areas. So you'll see those there. Administrative law. I'm just going to mention what these things are briefly. Administrative law is, I suppose, the best way to describe it is the law of reviewing what has been done by various people. For example, as I mentioned, I'm a member of the Queensland Civil and Administrative Tribunal. Well, the administrative bit for us is essentially the review of decisions that have been made by others, and the disgruntled person who was the subject of that decision appeals to the tribunal to ask for that decision to be reviewed. We call it a merits review in that situation. So, for example, if someone is denied a blue card and they need their blue card, the appropriate avenue of asking for a review of that decision is to apply to QCAT. So that's administrative law. Another thing is that the review can be made to the courts pursuant to judicial review in certain circumstances. And I'll just get whoever has unmuted or joined us, if you could just mute your microphone, that would be great. Civil procedure, well, that's pretty much everything which isn't criminal procedure. So criminal law, of course, deals with the issue of prosecution, and that's generally done by police, but it can be done by the Director of Public Prosecutions. It can be done by the Crime and Corruption Commission, for example, Or occasionally, very occasionally, you have private prosecutions. So if anyone's ever been disgruntled that action wasn't taken in relation to criminal activity by the authorities, then it is technically possible to bring your own private prosecution. I've never been involved in one of those, but you could do. So civil law is everything other than criminal law. And we've got some examples here: company law, constitutional law, contract law, equity, evidence, professional conduct, etc. So they're the different types of practice areas. Tort law is really talking about seeking redress for essentially the wrongs that have been committed upon you by, let's say, your neighbour. And I'm saying neighbour in a literal and figurative sense. So examples of tort law. Has anyone read any tort law? Do you know what I'm talking about? It's not cake law. Does anyone give me any example of tort law? Negligence, thank you, Rowan. Any other examples of a tort? T-O-R-T. Defamation, yep, thank you, Hannah. It's where you are wronged by someone else. All right, so nuisance might be another one. Yep, duty of care, thank you, Justice, is the overriding principle that guides, if you like, tort law. And that's the neighbourhood principle that was outlined in the case of Donoghue and Stevenson, which is worth a look. Okay, so they're the different branches of law. Discrimination, accident, injury, yes, Diane. There are more practice areas. I've mentioned environmental law. There's alternative dispute resolution, for example, which is another course that I take. So these are different practice areas. I'll get you to read something about making the most of your legal education. One thing you might want to consider doing is it would be interesting if you could think about how your studies can be applied even from now. So for example, I'm in the Hervey Bay area, and I set up a community legal centre with my then partner, who is now a magistrate. And I still volunteer. I still go along and give advice for free when it's my turn on the roster. But I do so with a condition, and that is that law students must be able to attend with me for experience. So now a couple of lawyers are doing that as well. And if you're in a position where you can accompany someone either on a day in court or to go to a community legal centre, I would absolutely urge you to take that opportunity to do so. So fairly regularly I have students that ask if they can essentially come with me on a day in court, and I'm happy to have them come along, get them keeping busy, speaking to prosecutors, dealing with various issues as well. So that might be a good way to do it. The other thing is occasionally you have an opportunity to deal with issues in a mock trial. A mock trial is just a mock-up of a trial, and I'm having one in about 3 weeks' time in Hervey Bay in courtroom number 3, which is the big one, and that's all being done through the Law Association. I'm the president of the Law Association. So if you're in Hervey Bay and you're interested, let me know, and by all means you can come along and you can even participate, you can play a part. So if you have an opportunity to involve in a mock trial, that would be great. All right, so your legal career and your professional identity, pages 33 to 38, have a look at that. The identity begins early. Your academic integrity stays with you. Those of you that have looked at the first assessment piece will be acutely aware of that even now. So it's important that you understand that what you're doing now potentially can affect, perhaps in a good or bad way, what's happening with your legal career. So issues like plagiarism, cheating, and collusion may lead to difficulties down the track. Now, if you're listening carefully, and I will come back to what's being discussed by Diane and Megan, thank you. If you're listening carefully to what I've said this week and last week, and I'm just giving you a clue, plagiarism, cheating, and collusion may lead to failure to successfully apply for admission. Is there anyone puzzled? That last statement, on the face of it, is directly contradictory to something I said last week, I seem to recall. Laws like this. Get used to it. Does anyone know what's wrong with that statement? Plagiarism, cheating, and collusion may lead to failure to successfully apply for admission. Matthew says collusion, working together. Collaborating is one thing, collusion is something else. Yes? Good. You've picked up on what I'm after. And it's that subtle difference between collaboration and collusion. And you're entitled to say, this is doing my head in, because I want to go as far as I can appropriately, but then not go too far. And I'm just going to highlight it for you as an issue. Think about that when you're reading the cases which have been set for you for assessment number 1. And think really carefully about what is that difference between collaboration and collusion. Because on the face of it, it seems like I'm telling you completely different things, because I do want you to collaborate. All right, as a lawyer, you have a duty to the court in the proper administration of justice. That is, you need to be truthful and duty not to mislead. But you also have a duty to the client, and that involves confidentiality, competency, loyalty, avoiding conflicts of interest. All right, so what does all that mean? And having said that, I'm still aware of your conversation, Megan and Diane. I will come back to that. So what do we mean by the duty to the court and the duty to the client? And can they clash? What happens if there is a clash between them? All right, if there is, let's take an example. You're acting for a client in relation to a trial, criminal law prosecution, and your client says, yeah, I did it, I'm guilty, but I want you to go to trial and plead not guilty for me and run the trial. By doing that, am I confusing my duty to the court and my duty to the client? Okay, some answers coming through now, and we'll have a look at those. So, well, I'm having trouble keeping up with you. Good on you. This is very good. Just when I get to it, we get some more, which is great. So keep them coming in. I will catch up with you in a minute. All right, so the first duty is to a court. That will override the duty to the client. I agree with that. Refer them to another solicitor, Ashley says. I would have thought the obligation would be the client. A different view there. If a client admits guilt, can't you represent them? Because who's that for you to decide? Innocent until proven guilty, attempting to pervert the course of justice. Who is it to decide who is innocent or guilty? I would have thought by representing them to get the best sentence, even if they are guilty. So lots and lots of different views and comments coming through. All right, well, think about that specific question. That may be something on the exam, something about the clash between your duty to the client and your duty to the court. Generally speaking, you can act for a client who does want to plead not guilty, even if you know they did it. But you have to be very careful, and you need to you can only be very limited in what you do. You cannot put something to the court which indicates that your client is in fact not guilty. You know your client is guilty. What you can do, though, is you can essentially say nothing, your client can say nothing, and you can see if the police or the prosecution can prove their case. See, we've got to remember, of course, that the obligation in a criminal law proceeding is upon the prosecution to establish their case beyond all reasonable doubt. So you're entitled to remain mute, essentially put up nothing and just see if they can do it. That's okay. But what you can't do is, for example, introduce evidence of an alibi, saying, well, my client couldn't have committed the burglary because on that night he was somewhere else and here's a witness who says that. If you know that's untruthful, you can't present that to the court. And if it gets to the stage where your duty to the court and to the client are clashing, then you should withdraw, and the overriding duty is to the court. above that of to the client. Okay, so it's probably different to what you may think, but that's the way it is. So very importantly, and this is definitely an exam hint, do have a look at the Australian Solicitors Conduct Rules, and you should see links for that in the on the Moodle page. So can the court draw negative inference from your client's silence? No, the court shouldn't do that. There are some specific circumstances where the court can draw an inference from certain things, but generally speaking, it works the other way. So, for example, prosecution prosecuting a case, and the court becomes aware that there was a witness who saw everything, but prosecution don't call that witness to give evidence, then it might actually go the other way, and defence might be able to say that the court is entitled to perhaps consider drawing an inference from the fact that police did not introduce that evidence into the prosecution. But it doesn't work the other way. And the reason it doesn't work the other way is that at no time does the defence have an obligation to disprove the prosecution. Well, there are some exceptions, but almost always the defence does not have to disprove. So I'll try and avoid the double negatives. The onus doesn't shift to the defence. It's always on prosecution. I mentioned a few exceptions. There are a couple of exceptions. There are certain charges under our code which do reverse that onus, but generally speaking, almost always, the rule is that if prosecution is being brought by police in relation to criminal activity, the prosecution has to prove that the defendant is guilty, and they have to prove that the defendant is guilty beyond all reasonable doubt. Okay, did we catch all that? So court still has to prove the client guilty. Well, the court doesn't actually prove the client's guilty. The court may find that the client is guilty, but the court doesn't need to prove anything. Prosecution do. Does his honour or her honour make a reference to the jury that no inference can be made by the defendant not giving any evidence? That's a great question, Scott. And the answer is that his or her honour will will actually specifically address a jury and say very clearly that no inference should be drawn by the fact that the defendant chose not to give evidence, or that the defendant chose not to call evidence. Giving evidence means actually the defendant getting in the witness box, and calling evidence means the defendant calling others to give evidence on his or her behalf. You know, I'm going to give you a little tip. Now, this is a bit of an inside tip, so I'm going to whisper it, okay? So listen carefully. It's not illegal or anything, it's not immoral, but it's something that I found out not that long ago. You can actually go online through probably the court's website and have a look at the bench books. Now, these bench books are used by judges, say district court judges, and they provide a kind of standard script to be used in certain circumstances. So if, for example, the judge was required to give a direction to a jury that no inference can be drawn because the defendant did not give evidence, well, the judge can just say what he or she wants to say, or they can go to the script, they can go to the bench books, and you'll see it all laid out there. So that's a really great tip when it comes to dealing with criminal law. Anyway, don't tell Lance I told you that. But don't worry, it's not illegal, it's not immoral, you can use it. I'm just suggesting that it's something I didn't immediately know for some time. Okay, so it's definitely odd, says Megan. So if someone comes to you and admits they're guilty but says they want you to represent them as not guilty, it seems that you can't ethically do that. Yeah, you'd think that, but sometimes, we do things that you'd think are not right. We can do so, but it's only in limited circumstances. Now, Megan and I think, who was it we're having a chat about? Oh, wow, you've had a lot of things to say. It's been great. Diane and Kimberly and Megan were talking about, whoops, it's gone again. I think the community legal centres and taping something. Now, where is that? Can we video it and put it on the Moodle site for those not able to attend? yeah, talking about the mock trial that I'm doing in a few weeks' time. Look, that would be really good. I'm not sure how I might be able to get around that. What I need is someone who's actually very good at having a camera that I can upload as a YouTube video. The best I could possibly think of at this stage is to take my laptop, set up a Zoom session, and then record it that way. But it would be a very limited view, and you'd hear mostly voices rather than seeing things. If anyone can give me some tips, maybe a GoPro. Thanks, Nick. I don't know what a GoPro is, but I'm happy to learn. So if anyone can think about how I can do the mock trial, which is in Hervey Bay, I think mid-August, it's a Wednesday, it's maybe the 12th or something, then if you're in Hervey Bay at that time, then please let me know. I'll put up some information about it. And so the suggestion is that I use a GoPro, and I'll have to find out that. All right, so I will try to record the mock trial, but I won't make any promises. Okay, so let's keep moving on. Chapter 2 of your text deals with fundamental legal concepts. We talk about Parliament and courts. Can anyone, if I was to say, okay, well, let's do a little bit of word association now. I'm going to say Parliament dash something law, courts dash something law. Now, I need to know statute, thank you, Lisa. Parliament dash statute law, courts dash, thank you, Matthew, thank you, Kimberly. Yes, common law. That's it. Very good. We're on the ball. We're listening. So Parliament is statute law, courts is common law or case law, common law. Now, all right. Now, number 1 is statute law. Number 2 is common law. In a fight between 1 and 2, who wins? 1, 1, 1, statute, 1, 1, 1, statute. Yep, got it. Okay, I think we got the idea. Statute law wins in a straight fight between the two. How many different types of... No, I won't go there yet. I'll come back to that. Relationship with the UK, Constitution of Australia, which was actually an Imperial Act, Statute of Westminster, Privy Council, appeals from the High Court Act 1975 and the Australia Act 1986. They're all pieces of legislation that are important in the context of Australia's relationship with the UK. So when I started studying law, I'm sorry I keep talking about the 70s, but you know, it was a good decade for those that missed it. When I first started studying law, a lot of my time was actually in the law library. It was all paper, of course, and I would be going to things like the All England reports and the King's Bench reports and I've forgotten even the names now, Chancery reports. So these were all English reports. So a lot of our law was English law, but the Privy Council appeals from the High Court Act in 1975 essentially stopped that, and up until that time, people could appeal to the Privy Court, which is kind of the High Court in England, but for places like Australia. So now the highest court that we have in Australia since 75 is the High Court. All right, now, just a yes, no. Have you started looking at things like Ostly and Com Law and Australian Guide to Legal Citations? That's a yes. Yep, yep, yep. All right, so we are starting to look at it. All right, and I trust that we're learning from that. Now, has anyone had a look at Barnett Jade? Barnett Jade. Has anyone looked at that? Yes, a couple of yeses. No. It's a really good one. Okay, so if you want, I would like you to have a look at Barnett Jade. I think I've put some details on the website about how to access them and some commentary about it as well. So it's unauthorized, but it's very popular. And all right, here's another tip, but I have to whisper it because it's really important. And if you want to get a bit of an advantage, here's what you can do. If you go on the website for Barnett Jade, you can subscribe to receive daily updates. And it's free. You just nominate what area of law you're interested in, and every day, if you want, you'll get an email of the latest cases from the jurisdictions that you ask for in relation to that field of law. How good will you look in the contract law examination if you make reference to a High Court decision right on point that was decided last week? You are going to knock the lecturer's socks off with that, and that's all because you're getting it delivered straight to your email account or your phone in relation to that area of practice. Okay? So if you want to impress a magistrate or a judge with your legal knowledge, you've got to be up to date, and Barnett Jade's a great way to do it. Okay, but we're whispering some things tonight because they're really like inside information here. It's all legal, it's all free. Is the website available through library links? Probably not. Google, you'd find Barnett Jade easily through Google. I have actually got the web address on the Moodle page in an area. If it's not, I apologise, but I think it is. I'm just looking now at my Moodle page, and maybe I haven't. Let me see if I have. Sorry. All right, I'll make a point to ensure it's there. If it's, and I'll let you know where it is if I have put it there, and if it's not, I'll put all this up on the web page. So it's some information about how to find these various places. Okay, any questions? Right, we've got Tim and Rowan have given us the address. Thank you. Info re Jade. We'll put that on the website. Okay. And then, of course, we have the course learning outcomes, which we should all be familiar with. No doubt, I take it everyone's registered for UCrew now, and you're following conversations in UCrew. That's where I want you to put your discussion pieces. I would really like you to start thinking about adding content. So, for example, if you find a website that's great, or an article, or a tip, then don't just wait for me. Make sure that you pop that up on there as well. All right. We're only just starting week 2 material. I'm sorry I'm behind, but I'll be chasing my tail a bit this term. I can see it happening already. And someone says the library video was a great way to go as well. So that's good. All right. So I take it you've all had a look at your written assessment. Now, you will be wondering how you go about determining what we mean by the material facts, the legal issues, applying the law to the facts, and the judgment and the relevance. So I'm really talking about assessment number 1 now. Okay, so we're listening carefully. Assessment 1. In week 4, which will probably be almost too late for you when it comes to your assessment, because we have the video on the Wednesday and the assessment's due on the Thursday, sorry. But in week 4, I'm going to discuss various methods used by legal writers to produce material. And the way things are going, it'll probably be week 5 anyway. But here's the acronym, MIRAC, M-I-R-A-C. Does anyone know what that acronym might mean? M-I-R-A-C. And I'm doing that in the context of material facts, legal issues, applying the law to the facts and the judgments. Okay, so M stands for material. Yes, material facts. There we go. Tiffany's got it. Material facts, issue, rule, application, and conclusion. Did you get all that? So that's MIRAC. Material facts. So the facts, the issues, the rules, the application, and the conclusion. So what does all that mean? Well, the first thing is that if you're sensibly going to talk about a case, or you're sensibly going to give some advice to a client in relation to a real-life legal issue, you need to discern what's actually a material fact, what's important, and what's not so important. Have a look at page 270 in your text at some stage. If you want to work ahead, you'll see a really good example of what we need you to do to work through to determine that issue. Okay, so let's say we have a situation where we have a dispute in relation to a contract. And in the facts that are outlined to you, or the facts that are presented to you by the client when you're taking instructions, the client says to you, look, I signed the contract with a blue pen, not a black pen. You've got to work out whether that's a material fact or not, whether that actually makes a legal difference. If you think it does make a legal difference, then you will say, yes, that's a material fact. If you say it doesn't matter whether it's blue or black, then you would ignore that. It's a fact, but it's not a material fact. It's not going to change your opinion or your advice. So that's probably what you need to consider. If there was a dispute in relation to the quality of a motor vehicle, and you're acting for a client who complains that the vehicle is faulty, not of merchantable quality, and the client says to you, and I really wanted to buy a red one, so I waited 2 weeks longer specifically so I could buy the red car, does it matter that it was red? Now, it might matter to the client very much, but does that matter from a legal perspective? Is that going to change your advice? If the answer is no, then it's not material. If you say, yes, it is going to change my advice, then it becomes material. And you might say, well, it's material because the client paid more than it would have cost to buy the white one. So then suddenly something that appears not to be material might actually be material if you ask another question or two. So what is a material fact can change in the circumstances. So just be alert to that. All right. And I'm saying this in the context of giving you some early assistance on how to answer the first assessment piece. So you've got to work out what's a material fact. So when you're reading Humsey Hancock and you're reading all these things that happened, you've got to be thinking, well, is that actually important? Was that something that the judge considered in concluding the case the way it was concluded? Or was it just something which is incidental, not really important to the law? So that's M for material. Now, just as a refresher, I know that we did get this right, but what does I stand for in MIRAC? What's the I stand for? Issue, issues. Yep, issue. Right, we got it. Issue. Right, what do we mean by the issue? Well, we've got to work out what the legal issue is. Is it contract law? Is it torts law? Is it a constitutional dispute? Is it a consumer dispute? Is it criminal? So when you're presented with a whole lot of facts, you're not likely, the client's not likely to walk into the office and say, look, I have a contract dispute. It's also a consumer dispute, and you may need to look at the Australian consumer law as well as the common law in relation to contract to give me the appropriate advice. So the client's not going to know what the legal issues are necessarily, but you have to work that out. What type of law are we talking about? What are the appropriate legal issues? Now, there might be issues that aren't obvious unless you know a bit about the law. For example, if a client comes in and says, I have a contract dispute, I have a signed contract, I want you to sue for damages. Now, on the face of it, you may have a perfectly good case until the client says to you, yes, and the contract was signed 7 years ago. Does anyone understand why that might make any difference at all? Why would the fact that it was signed 7 years ago suddenly become a legal issue? Right, invalid time limitation, statute of limitations, change of laws limitation. Probably what I'm getting at there is the issue of statute of limitations. So, and it may not have been relevant unless you asked one more question, and then it did become a legal issue. All right, so when you're looking at a fact or making a description about law, you need to identify what the legal issues are. What does R mean in MIRAC? R, what does that mean? Rule, rule, rule. Okay, we got it. Rule. So what are the rules? Another way of saying that is, what is the law that applies? So we've identified that the material fact is that a contract was signed. We've identified that it's material, that the contract was signed between two people. We've identified that an issue is the possibility of the statute of limitations taking effect, or the Australian consumer law applying. I'm not necessarily saying they both apply, but these are sorts of issues that may apply. We then have to determine what the rule is. So what is the rule that is important to be applied in this instance? So you've got to outline the rule. So one way of doing this, I guess, is to say, and you can even have headings, material facts. Here are the material facts. Next heading, issues. Here are the legal issues. Next fact, next heading, rules. What are the legal rules? What's the next one? A. What's the next heading? What does A stand for? Application. Yep, application. Applying the rule to the issue, application. All right, so we're going to talk about how it's applied in this case. So what we're saying is the important things in this case are these things. The issue here is this. The rule that needs to be applied is this. And when you apply the facts of this case to the rule, you come up with a final C. What's the C? What's the heading for C? Conclusion. Okay, so there is a bit of logic behind MIRARC. Yep, conclusion, we've got it. So there's nothing wrong with outlining your paper in that logical way of legal thinking, MIRARC. Have a look at page 270 if you want some ideas on that. And I'm just giving you that as some possible assistance when it comes to answering that first assessment piece. All right, well, I think we're getting close to the stage where I should wrap it up. I'm very conscious of the fact that I haven't touched on Indigenous Australians and the law, which is pages 85 to 91. I haven't yet touched on terra nullius. I haven't yet dealt with native title, the development of British law, legislation and common law and equity, and equitable principles. We might save some of those for next week. And yes, I know I'm behind where I should be, but keep reading on, keep working ahead as you're doing. Now, Rhiannon says, is there an example of a case note that we can look at? Yeah, if you look at any case which has been reported, you will see essentially a case note through the head note. Otherwise, you have textbooks. Some of these, for example, these nutshell series are really good if you want to get a summary of a case, but you can get a lot of those things over the internet as well. So I'm not sure if that's what you meant by a case note, Rhiannon. What depth of material facts do we go into? Humbly, section 2 seems to outline the facts. Should we go deeper? No, you don't have to. I mean, outline the facts with as few words as you think is appropriate. When we're talking about the material facts, just ideally identify what they are. And if you believe that, now I'm not sure what you mean by section 2, but if you're looking at section 2, if that's sufficient, then by all means you can leave it at that. But I won't go any further in any commentary about that at this stage. Okay, well, you've all been very good sports. Now, does anyone have any questions for me? Is anyone brave enough to unmute their microphone and actually ask a question? Not one person? All right. And who's going to take me on in the typing challenge at the end of the year in week 12?
I've got a question.
Yes. Thank you.
With the problems of each day, are we graded on them?
Is that you, Laura?
Yeah, I've still got the Duna thing happening. Sorry.
No, you're right. No, you're
not.
No. Now, those problems each week in Moodle, they are really to help you focus your thinking. They're to help you with your blog, so that'll make your blog easier, but you're not graded per se on those.
But how do we know if we're doing them right?
What's that, sorry?
How do we know if we're doing them right?
I'll give you some feedback, but I must confess, I won't give feedback individually to 100 to each of you all the time on each one, but I will give some generalised feedback. And if I think you're on the wrong track, I will let you know. I hope that answers your question, Laura.
Thank you. Yes.
And thank you, Laura, and thank you, Duna, for asking that question. Okay, thank you.
Question as well.
Yes, please.
I'm just wondering about the blog with the assessment at the end. We're supposed to be doing, our own reflections. Is it a good idea? I'm not really sure if we're meant to be using the weekly reflections and putting that on the blog, or if we're just kind of going along throughout the term and just doing it ourselves when we feel like we want to. I'm just a bit confused with that.
Yeah, sure. No, that's a really good question, Ellen. Thank you for asking that. The problems that you have each week, by all means, they can go in your blog, and that can be part of your blog. I suppose it could be all of your blog, or it could be some of your blog. You don't have to answer each question every week. That's not a mandatory requirement. You're not going to be marked down if you don't. And typically, of course, towards the end of term, when people are doing other things, we see the numbers of responses drop off. So I expect that. But it will help you to answer your blogs. And when it comes to your blogs, you can reflect on any learning that's happening. So, and Megan says you can also, you can reflect on other learning happening in the same term. For example, in contract law, if you're doing that, fine, no problems at all. So it's really just an opportunity for you to show that you are actually thinking about this and not just content with repeating words back to me. Tonight, for example, I've stressed certain things in relation to what it means to be a lawyer these days, and some things about resilience, etc. So you might want to reflect on that in your blog if you think that there's something important in that regard. Okay, Lisa, did you have a question for us?
No, I just lost connection, so I've just come back on.
Oh, okay, fine. No, that's all right, Lisa. Thank you. All right. Now, does anyone else have a question? And thank you very much for those who have actually unmuted the microphone and come in and asked a question live. Are there any others? Yes.
I just wanted to ask, what are you exactly looking for in terms of the blog? Because it's not something I'm really used to doing as far as writing reflections go.
Yes. Thank you, Nicholas. There is no actual right or wrong answer to this, because I think last week did I say that, and I'm sure I would have, that one of the advantages in studying law is that there's not necessarily going to be a right and wrong answer, and that what we're really interested in is the process, the logical thinking, the way you put your thoughts together, the way you present your argument. All of those things are important. It's a little bit like that with the blogs. So if, for example, you wish to discuss what you believe to be the most important piece of legislation introduced into law in 2015, well, I can't argue that it's not the most important, or it is the most important piece of legislation, because it's really a reflection of your thoughts. And what I'm looking for is for you to tell me why. Why is this important? Why has it meant something to you? Where has it changed your way of thinking as a result of reading this material? So I know that's broad and it's vague, Nicholas, but it's just a chance for you to provide some insight and some reflection. Some people write a lot of words, and I'll read it. I'd prefer it wasn't too many, because if you present a blog in total which is 20,000 words, that'll take me a while to get through. So I'd prefer it wasn't that. I'd prefer some nice quality over quantity. So that'll be of comfort to you when it comes to determining how many words you need to write, I hope. But thank you, Nicholas. That's a great question. Now, I think there's a question down the bottom. So Kimberly has given some idea. What has your experience of education been like? Has it met your expectations? Yeah, they're great sort of questions. So thank you, Kimberly.
Only other question I've got is, can we write about law from other areas of the world? Because I personally follow US law pretty closely, because I'd like to practice in the US one day.
Absolutely. We'd love to hear about what's happening in the US law. So that'd be great. if someone wants to write some material in relation to what's happening in environmental law and alternative dispute resolution, that would help me. But no, great international law, that'd be terrific. Thank you, Nicholas. Any other questions?
John?
Yes.
Just one question. Will the MIRARC model assist with distinguishing between the rationale discendi and obedicta?
Yeah, absolutely. All right, so that's a great question. It's Jesse, isn't it? Great question, because you would have read about the ratio and the dictum, to use the abbreviated forms, which is essentially the distinction between that part of the decision of a judge which goes to the heart of the case and which helps to make the decision in that instance, as opposed to the dictum, which are really, and I don't mean to minimise this, but they might be regarded as throwaway lines. So it might be that a particular case which deals with an issue requires the court to make this ruling on a piece of law. That then becomes part of the common law. But in the course of doing that, the judge might say, but also, let me say this. If it had been a different situation, this is what I would have come up with. So that's a colloquial way of saying it. So it's not the dictum, which is the throwaway line, and don't use that as a quote. That's not meant to be. That's not an appropriate description. It's just a way of exaggerating in an exaggerated way, trying to make my point. So the throwaway line, the dictum, wasn't actually necessary. The judge didn't have to say it in order to make the ruling. But well, if a High Court judge provides an opinion by way of obiter dictum, then people will listen to it, and you're perfectly entitled to raise that in another case as something which should be considered by the court that you're dealing with at the time. Okay, so yes, the MIRARC system would help in making that distinction, because when we're talking about material facts, we're really talking about material facts for this particular case. So thank you very much for that. Nick's come up with a great website in relation to blog writing. So thank you, Nick. Now, are we able to submit a draft of assessments due before the due date so we can get some feedback to fix it before the due date? Unfortunately not. Sorry, Rhiannon. Sorry, Ellen. But I don't have a practice of looking at drafts. So you've got to submit what you think is the right thing to do. You can compare notes on UCRU by collaboration, but no collusion, to look at that example. Okay, are there any further questions? It's been some really good questions. I really appreciate it. Any questions on the chat facility? Nobody live?
I've got one, but it might be one for administration. I don't know how to submit my assessment. Is it a document form, or is this something I should take up with administration?
Thank you. Sorry. Sorry. I'll say all that again, but I won't use as many words. Thank you, Laura, for your question. The document is a Word document, and it is uploaded through Moodle. So for the first assessment piece, go into Moodle, and it should be quite simple for you to take your Word document and upload it through the Moodle site. And there are some guidelines in Moodle, which I've given, as to the sort of way I'd like the document set out. You know, for example, 11 or 12 font, etc. Thank you, Laura. I hope that answers the question eventually. Are there any other questions? Okay. All right. Well, thank you very much, everyone, for your participation tonight. I really appreciate it. Keep up your discussions through UCrew. Share your material. It's very good karma. And we will meet again next week. All the best. I'll stop recording now.